Welcome to the Pearson Show's Personal Injury Postscript.
Hey everyone, welcome into an all-new episode of the Pearson Schaus Personal Injury Postscript with attorney Chris Schaus. I'm your host, Mike Leon. Chris here is a Baton Rouge personal injury attorney who has been representing clients across southeastern Louisiana for more than 30 years. He began his career in insurance defense before founding Pearson Schaus in 92, where now he focuses on helping accident victims rebuild their lives with clarity, compassion, and strong trial advocacy. In today's episode, we're going to be talking about Louisiana's new comparative fault law. Chris is going to go over what it means for drivers, riders, and injury victims all across the state. Chris, it's good to see you as always. Let's start at the beginning here, which is, could you start by explaining what the comparative fault law means in an accident case in Louisiana?
Sure, Mike. Good to hear from you once again. Comparative fault is a concept that's undergone a lot of change over many decades. When I began practicing, we were still talking about the transition from contributory negligence to comparative law. Back in the old regime of contributory negligence, if you had any fault, your injury, any degree of negligence, you might be barred from collecting at all for your injuries. And obviously, that regime had a lot of fundamental fairness problems. And so the legislature saw fit to transition Louisiana, like most states, to a pure comparative fault regime, such that a fact finder, whether judge or jury, would be asked to determine which of the defendants or parties, including the plaintiff, had what degree of negligence. So a plaintiff who was 30% comparatively at fault, who bore 30% of the fault for causing their injury, would see their damages award reduced by 30%. Likewise, a plaintiff who had 75% negligence was still able to recover 25% of their damages, or wherever the comparative fault allocation broke out, the damages would be apportioned pro rata in accord with that fault allocation. What's changed is in our most recent episode of adjusting tort reform, we're trying to strike a balance between the rights of the injured and the rights of the insurance industry. And so where we are now is we've gone to a modified comparative fault regime, and it's a very important distinction. Now the rule is up to 50%. If the plaintiff is up to 50% at fault in causing their harm, then their recovery is reduced pro rata in proportion with the amount of fault that the fact finder has apportioned to the plaintiff. Except that if the plaintiff's fault reaches 51%, then that acts as a complete bar. So a plaintiff who is 50% or less at fault in causing their injury recovers with a reduction for their degree of fault. A plaintiff who is 51% or greater loses the right to recover. So pretty big change there.
Huge change. And I would love for you to expand a little bit more on why that 1% is making such a big difference, especially when it comes to the settlements or jury verdicts.
Well, I mean, it's a tort reform tactic. It's just another filter to weed claims out, to reduce the claims. And they're able to get some sympathy for that argument that, hey, if this accident was mostly the fault of the plaintiff's negligence, the majority of it, a plurality of it was the plaintiff's fault, then you can make that argument that fairness dictates they shouldn't recover anything. Obviously, that 49% at fault defendant says, wow, they sliced it pretty fine, and I got lucky and came out on the right side of that. That 1% shift makes a huge change. And the kind of accidents that come to mind for most people, they say, well, that's not going to be a problem. I would only be suing if somebody ran into the back of me or something like that. But of course, we see plenty of multi-car and intersectional collisions and chain reactions and situations like that where it's very difficult to get down to precise percentages of fault. It may be a portion among 3 or 4 or 5 different defendants. There may be pieces of the chain of negligence that you can't really completely evaluate until you've had extensive discovery, or maybe even until you've had the trial testimony. So there are certainly many scenarios where there's a concern that you may go the distance, go all the way to trial, and find evidence at trial that swings that percentage by just a point or two, which is enough to tank the whole case.
Right.
So it greatly increases the risk to claimants, most particularly in multi-car accidents or complex negligence scenarios where it's not clear at the front end of the claim exactly how the negligence is going to shake out.
So, Chris, we've talked about the percentages, but when a crash happens, like, who's actually deciding these fault percentages? Is the insurance adjuster? Is it the judge, the jury?
Well, kind of everybody who touches it makes some judgment about it. The officer who investigates the claim certainly takes his findings and typically makes at least a preliminary fault analysis. The officer's analysis and the accident report are not binding or determinative. The real determination is what's made by the fact finder, either the judge or the jury. That's what's going to matter in the end. But on the front end of the claim, it very much matters how the adjuster, how the claims personnel in the defendant's company, how they read it. We spend a lot of time trying to educate those folks on these sorts of factors. If we're successful, we can get the claim resolved short of trial. If not, we'll make the presentation to the fact finder, whether judge or jury.
Yeah. Chris, you mentioned a couple of things there, and I'm wondering if these are the kinds of evidence that help prove it. You mentioned about the police reports and things like that, but what kinds of evidence help prove how much fault each driver in the accident should carry?
Oh, we look at all sorts of things. Obviously, nowadays, with so much camera technology, a lot of folks have dash cameras. Took in a very serious motorcycle accident just in the last few weeks. 2 riders out together, and very fortunately, the second rider had a wonderful high-quality camera on his bike. It looks like movie footage. That kind of footage is very valuable. We do the same thing with traffic cameras and with security cameras from nearby businesses. So all of those are key evidence. We talk a lot with our clients, past and present, about at the scene, gather what you can. You've got a phone, you've got a camera in your pocket. Get a picture of the scene, get a picture of the damages, get a picture of the people that are there. Get as much as you can while you're at the scene. It's not uncommon for folks' testimony for their account of what happened to change between the date of the accident and the time the investigators start coming around. So if you can get photographs or recordings or video or any evidence at the scene, it's very critical. In addition to that, we use all sorts of methods. We use expert recreation of accident scenes. We're always gathering whatever physical evidence, looking at the vehicles, looking at the skid marks, the yaw marks, the officer's report. We'll send an expert out to measure components of the roadway or the vehicle or the damages. Nothing's out of bounds in the search for evidence.
Chris, we were talking about the percentage amounts earlier, so let's do a little bit more math here for the folks. So if someone is found just under that 51% line in terms of fault, let's say it's like 45%, how does that affect their recovery amount?
So an injured driver who brings a claim and is found to have contributed 40%, if they have a $10,000 claim, it's going to be reduced by 40%. It would be reduced by $4,000 there, 40%. And that's a top line reduction. So if that claim is a $10,000 claim because there's $3,000 of medical bills and some lost wages and some months of pain and suffering like that, that 40% reduction is to the top line award. If that award was $10,000, it comes off of the 10. So it's not just off of the medicals or just off the pain and suffering. It's a top line off the gross amount of the award.
And what about motorcyclists? How is this change impacting motorcyclists? Different maybe from drivers of automobile vehicles in Louisiana?
There's no statutory difference for the nature of the vehicle. The difference comes in the practical application. The many motorcycle accidents involve hit and run scenarios because people can leave a motorcycle accident. Oftentimes, that car that's involved, or truck or whatever, is still able and might have very minimal damage. Either it didn't impact the bike, or it brushed it, or merely forced it off of the roadway. But there may or may not be damage to the vehicle. And so there, we're dealing with a hit and run, and the liability issues become so much more complicated there. We don't have witnesses. We don't have physical evidence. And so I know motorcyclists. I'm a lifetime motorcyclist. Motorcyclists don't want to carry a camera on their bike, but a lot of them move to that after they've had a serious accident or a serious incident where they weren't injured but saw aggressive driving. Problems of proof are greater oftentimes with motorcycles. And so that's the biggest practical effect.
So, Chris, let me ask you as we wrap here on this episode, what's your best piece of advice for somebody out there that just got hurt in a wreck and this law has just changed for them? What's a piece of advice you would give to them?
Talk to somebody who is living and working in this system every day. I met with a gentleman this morning who, like so many of us, had an accident, not a terrible accident, not a terrible problem. And he says, I think I can probably take care of this one myself. I handled one of these 20 years ago. And the problem there is it is a totally different system with different players, different focus, different emphasis. The insurance company is not merely seeking an efficient resolution. Your claims specialist, they don't call them adjusters now because they don't have any authority. Your claims specialist is looking to get his average cost per claim lower than the folks in the cubicles on either side of him, because the specialist with the lowest claim cost is going to rise up. The others are going to get weeded out. And so they're under a tremendous amount of pressure. And it's not about a simple and fair and efficient resolution anymore. If they can beat you out of something that you're entitled to, they need to under the current system, and they'll work very hard to. Best to talk with somebody who knows the system and has recent experience in it.
Yeah. Chris, thank you for the time and insights around this topic. I appreciate it.
Mike, it's good to talk with you once again. I appreciate your questions.
And thank you everyone out there for listening to the Pearson Shouse Personal Injury Postscript. If you've been injured in an accident, car, truck, motorcycle in the state of Louisiana, don't face the insurance companies alone. You just heard what Chris said. Do me a favor, visit pearsandshouse.com, Shouse spelled SHOWS.com to connect with Chris and the team. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.